Ms Crozier.
Well, look, Minister, with all due respect, I think every Victorian realises that with the hotel quarantine breaches and the widespread failures in contact tracing that's led to the widespread community transmission, we're in this devastating situation because of the failures of your government. Now, you still haven't answered my question. I'm moving on because you keep talking about we need these measures in place, which nobody is denying. We're not saying that. No, that's actually because of the 6 month. We're talking about the 6 month here. And that's the thing that you don't quite understand because you're not actually listening to Victorians. So you were talking about a vaccine. We may never have a vaccine, Minister. We may never have a vaccine. We haven't got a vaccine for a whole range of other viral issues. So is the government going for an elimination strategy? Are you aiming for an elimination strategy? Because the Chief Health Officer himself said that the other day, that he would like an elimination strategy or words to that effect. So is that the government's aim?
Minister?
So the Premier has addressed this issue many times. The National Cabinet, of which he is a member, has agreed to an aggressive suppression strategy that has been the... Do you want answers? Do you actually want any answers, Ms Crozier, or are we just going to be yelling at me for the rest of the evening? So Deputy President, if Ms Crozier actually would like an answer, if she would like us to actually progress this debate in a civil manner, I'm explaining to her that the National Cabinet, chaired by her Prime Minister, and which Premier Dan Andrews participates in, the agreed strategy is one of aggressive suppression. And we are putting in place measures that are working, that are driving case numbers down. And she's made many claims about what's happening internationally. What I can tell you is I look quite regularly at what is happening internationally, and we are seeing many countries around the world experiencing a second wave at the moment. And are putting in place very similar measures, locking down particular cities, parts of their country, or in fact their entire country, with very restrictive measures, comparable to what we have been doing in Victoria. And you just need to look to New Zealand across the Tasman, that in fact had even more restrictive measures in place. And so what we see is that these measures do work. They do work. The approach that we are taking in Victoria is not unique to Victoria. It is. We know that the public health experts internationally agree that this is the approach. You need to limit social mobility. You need to limit people interacting with each other. This is a highly contagious virus, and the more people interact, the more quickly the virus spreads. And it's even healthy people that are carriers of this virus may not exhibit any symptoms or very mild symptoms that are contracting this virus and then passing it on to more vulnerable people in our community. And we've seen young people get ill with COVID-19, being hospitalised with COVID-19, end up in ICU beds, and in fact even have lost their lives. But it is the most vulnerable in our community, particularly those in our aged care facilities, who are put most at risk by this virus being out of control, and this is why it is important that we are able to continue these measures. And can I just say that we would have needed to have extended the state of emergency despite the second wave. We would have needed to have some baseline level of protections, as I've explained. WA has, New Zealand has. In fact, every state and territory across the country, regardless of their case numbers, continue to have states of emergency or equivalent measures in place, declarations in place, and legal directions that that accompany those declarations. So every jurisdiction in Australia is taking this approach, and this is the approach that we need to have as well.
Mr Davis.
Deputy President, my questions for the Minister start on one point, and I want to expand onto a couple of points. The first is the 6-month, 12-month decision, and the decision to seek to expand the state of emergency. Does the minister have legal advice that this was necessary, or legal advice that this was the best way to do these steps?
Of course, the government sought legal advice in relation to its approach in relation to these matters, and I can only predict the next question that the member will ask me. And of course, any legal advice that successive governments have had, including when Mr Davis was a health minister and was in fact the responsible minister for the Public Health and Wellbeing Act, simply received legal advice at that time, and that wasn't publicly released either. Of course, the government seeks advice, seeks legal advice, seeks public health advice in response to its approach, and we will continue to seek advice from experts, whatever their expertise may be.
Mr Davis.
Will the minister make that legal advice available to the chamber? I just want to hear it in the clear.
The member is well aware from his time as being a Minister of the Crown that legal advice provided to government is not publicly released, and I certainly recall having many debates with Mr Davis when he was Health Minister about the successive documents that he would refuse to release, and it wasn't just legal advice that we're talking about. It was a routine approach that Mr Davis took of putting everything into his man safe.
Mr Davis.
Deputy President, the answer I think is no. The Minister is not going to release that legal advice, but I will ask about that. First, does it talk about the infringement of rights and the opportunities and property rights and freedom of individuals? And if so, would she make those sections available to the chamber, given the SARC report is not available?
Minister.
I refer the member to the statement of compatibility that goes to the issue of the Charter of Human Rights that does provide advice to the House in relation to these issues. And I also draw the member's attention to the various provisions in the Public Health and Wellbeing Act, and I can advise the member that every time that I have received advice in relation to extensions of a declaration of a state of emergency, I have also received advice and considered implications in terms of the Charter of Human Rights and Responsibilities. So that happens as a matter of course, and both the Chief Health Officer and I, as the Minister for Health, are required to take into account the Charter.
Mr Davis.
The answer again is no. And I ask the Minister, in amongst that legal advice and alternative advice, including the Chief Health Officer's advice that has been referred to by Ms Crozier, did the government look at other alternatives rather than a declaration of emergency? See, it would be possible to amend the law and to put in place a framework that would enable certain more restricted options for orders to be made. Not a difficult thing. In fact, we had one draft that had some alternative ways forward on that. So there's no intrinsic reason why it has to be only under a state of emergency. Powers could be given, a specific set of powers, for example, for home isolation, for quarantine, for other matters, to the Chief Health Officer in a more narrow field than with a full-blown state of emergency.
Thank you. Obviously, I'm not going to canvass the details of any legal advice provided to government, but of course the government considered various approaches in relation to how to go forward with these matters. The member, of course, would be aware that currently Victoria is also subject to a state of disaster that has nothing to do with the bill that we have before us. It's not It sits with a different minister, it sits with the Emergency Services Minister, and of course there are different powers that are available to the government through that legislation, but it does not enable Chief Health Officer directions to be issued. And so it is considered that it is the appropriate way forward in terms of providing that continued public health protection to the community, to have this legal framework continue if it is necessary for a further period of 6 months.
There were alternative approaches, but you decided, in fact, on a more draconian and more extravagant approach with a state of emergency rather than a more moderate and controlled mechanism. I ask another question that flows from that.
Minister.
The member is making particular assertions there, and in fact, if he was to have a look at the state of disaster, the fact that the Charter can be paused, for example, in fact, the Public Health and Wellbeing Act
Minister,
offers
is this a point of order?
considerable checks and balances and
Minister,
safeguards in place
is it a point of order you're raising?
that are not available under the other legislation.
Mr Davis.
I'm not sure that is an argument in favour of the approach the government's adopted. It's just an argument of comparison with an entirely different act, and I don't think that that answers the point. My next point about this is relates to retrospectivity and whether this approach that's been put in here has any retrospective effect. So let me be quite specific here. We are aware of a number of legal cases that are afoot, and I want an assurance from the Minister that the clauses in this that apply to powers for the Chief Health Officer, specifically Clause 6, and I could ask there, but I'm asking in the context of this legal framework, in the Purposes Clause, whether that would affect any legal case that is either lodged or is afoot or relates to an order that has already been put in place by the Chief Health Officer.
Minister.
The bill is not retrospective in nature. Firstly, it's forward-looking. It extends the current powers available under the Public Health and Wellbeing Act for a further period of time. In particular, enables a state of emergency to be declared for in response to the COVID-19 pandemic, and it is specific to the current pandemic for a further 6-month period. I'm not aware of any case that may be impacted by this bill, but I point out to the member that the powers set out in the bill of the Chief Health Officer, or in fact myself as Minister for Health, are not changed. They are providing, there's some clarification that's provided in the bill, and the key change relates to the extension of the period of time. So the powers of the Chief Health Officer will continue in the same way, will continue in the same, well, they will continue in the same way. We'll talk about that because you've made all sorts of assertions about that clause, and it relates to appointing authorised officers. So I think there's been, anyway, that's clearly misunderstanding of what that particular clause is about. But as I've explained, this is not retrospective in nature and does not widen the Chief Health Officer's powers. They continue with the checks and balances and the various criteria and the process that is required under the legislation in terms of any declaration that I may make. And we've added additional transparency measures in the legislation as well in regards to my tabling the Chief Health Officer's advice to me in making any such extension of a declaration of a state of emergency.
Mr.
So the Minister asserts there's no retrospectivity and no change in powers. That is not my reading of it, and I put on record that necessary and reasonably necessary are not the same. Mr O'Donoghue will no doubt have more to say about that, but I think it does weaken the position of any litigant in the future. And my question, I'm assured, as I take it from what the Minister said, that there will be no retrospective component, and that I take to be a positive thing. My next point relates in terms of the legal powers that this sets up for the Chief Health Officer. These, and I think the Minister has said this, but I want to hear it again in the clear, is the Minister able to tell the House whether these powers that the Chief Health Officer would use relate to quarantine?
It's possible that the current legal directions that have been put in place in respect of ensuring that return travellers are required to quarantine would be legal directions that the Chief Health Officer would be keen for them to continue. In a similar way, the legal directions that are in place that relate to the need for a positive confirmed case of COVID-19 to isolate at home. It's very likely that the Chief Health Officer would want those legal directions to continue. But of course, he will make that assessment based on the particular circumstances that's necessary at that time. I think that would be very reasonable to assume that those two directions, at the very least, would need to continue as, I guess, a base level of protection for the community for some time, unless those opposite, don't want to see any traveller being able to enter Victoria again through international flights or a cruise ship, for example, coming to our ports, or international students returning to our universities, then there would need to be these types of measures in place.
We take from that, Deputy President, that isolation arrangements and also quarantine are at least two of the things that these new powers will apply to. And I ask, who will oversee the quarantine arrangements in this?
Well, this is very predictable, but we are now steering into territory that is unrelated to the bill that we have before us. This is about continuing the state of emergency, Mr Davis, you know that very well, and it continues the underlying legal framework that enables legal directions to be issued.
Mr Davis.
Relate, Minister, to private security arrangements inside quarantine.
Mr Davis, you know very well that this has nothing to do with the bill that we have before us. Absolutely nothing to do with the bill before us. If you want to ask questions in relation to these matters, there are other forums for you to do that in the Parliament and direct them to the relevant ministers.
Mr Davis.
The Minister doesn't want to answer that question. Well, it is actually quite relevant. Quarantine orders, as you've indicated, will be made by the Chief Health Officer. They may be for publicly or privately managed quarantine that's under the orders, and you won't tell us. You won't tell us whether you will oversee this yourself or someone else will oversee it. But let me ask another question, Minister. In terms of quarantine and the orders applying to quarantine, what have you learned over the recent period that will be applied with these new orders?
Minister President, this is just treating this whole process as a complete joke. There's a lot of people in the community watching this debate at the moment, and you are treating this as a complete joke. This is about protecting the Victorian community. If you want a grandstand, you had the opportunity to do that in the second reading debate. You'll have an opportunity to do that through other forums in this Parliament. But we need to get on with it. We need to focus on the clauses in this bill. This is a bill with 8 clauses. It only runs for a few pages, Deputy President. We've already been covering some ground in relation to Clause 1 in the past hour. I don't think we've covered a lot of significant ground because you're just using this as a totally politicised process rather than actually seeking to ask some important questions that I'm happy to assist you with. But if that's where if you just want to waste time in this way, Mr. Davis, we're not going to get very far.
Mr. Davis.
It's a waste of time. Is it really? It's a waste of time. You're saying you're irrelevant. You're an absolute disgrace.
Deputy President, if the Minister thinks keeping the community safe is irrelevant, if the Minister thinks that actually questions about how you intend to implement quarantine is irrelevant, let the community see that. Let the community, it's entirely relevant. You are going to promulgate quarantine laws under this exact head of power. You botched them last time. You're going to botch them again unless you learn some lessons. You don't want to learn any lessons. You don't want to actually pick up some of the things that you should be learning. But nonetheless, let's move on. Let the community record that the Minister does not understand that the botched quarantine approach has not made the community safer. It's actually made the community less safe. And I'm interested in it being improved. Minister, I'd just like to ask you about the doctor's letter that was released today. And I see from the letter that there's at least 13 senior doctors who have signed it. Obviously, doctors are a varied group in terms of their specialties and knowledge, but all of these doctors are in contact with patients and broad community as well as the health community. And I ask you on this matter, have you read the letter that was released by, and I'll read the Wells, Miller, Barre, Grills, Murder, Walter, George, Denton, Edwards, Taylor, Knight, Mattei, Matheson, and I understand that there are many others who support the matters that are raised in this letter. And let me quote, the purpose of this letter is to make you aware that not all medical practitioners, as a letter addressed to the Premier, are in agreement with the Chief Medical Officer and the Victorian Government regarding the most effective way to control this disease, COVID-19. We believe that an alternative medical response is required that reflects what we know about the spread of the virus and those who have died from it. And it goes on at some considerable length. It calls for the release, in common with many other medical groups, for more information from the government. The government has not been as open. It makes some recommendations. It says the state of emergency not be continued past the 13th of September. It says ensure adequate measures testing protection of the vulnerable, especially those in aged care. Clearly communicate to the public medical evidence-based objectives and timelines for proposed future management plans and open disclosure. It goes on, a broader focus should be given to the health and wellbeing of Victorians by utilising relevant available data, and it seeks to review the outcomes of any management decisions and demonstrate a willingness to modify plans as new data and insights become available. I've summarised the letter. If you have not seen it, I'd be happy to provide you with a copy of it and ask you, would you meet with that group?
Minister?
I can inform the member that there are plenty of doctors lobbying for the extension of the state of emergency, and I refer you to the President of the Victorian AMA, Julian Raitt, who was quoted on the 27th of August as saying, quote, "I would be supportive of increasing the terms of the emergency powers because I think that they are necessary to make sure that we can continue to keep on top of the virus to maintain the welfare of the Victorian people," end of quote. Similarly, the National AMA President, Tony Bartoni, said on the 25th of August, quote, "The CHO's directions need the framework of the state of emergency," end of quote. So the peak body for doctors, the Doctors' Union thinks that the state of emergency should continue. The Victorian Ambulance Union The Victorian Ambulance Union, Danny Hill from the Victorian Ambulance Union has similarly put on record his very strong support, and the Victorian Ambos Union very strong support for this extension. And I quote from his statement of where he says, quote, "The VAU supports this proposed logical step and will be contacting Victorian members of Parliament, calling on them to support hardworking paramedics and ambulance workers who are on the front line of this pandemic. The stress and pressure that our members are experiencing during COVID-19 cannot be overstated. They face daily risk of exposure and are likely to be heading into hot summer where every day they'll be wearing full PPE if the virus is not contained. Having strong protections in place is an absolute must, and we fully support any legislative change that delivers those protections," end of quote. And also I refer you to the Australian Nursing and Midwifery Federation. Both Lisa Fitzpatrick, the Secretary of the ANMF, has been very strong in her support for the extension of the state of emergency, and the Australian Nursing and Midwifery Journal of the 25th of August was quoted as saying, we want our politicians to let nurses, midwives and aged care, personal care workers know that you have their back by passing the law to provide a framework for a COVID-safe normal once this outbreak is under control, and to quickly respond if there are further outbreaks after this wave," end of quote. And finally, the Police Association, Wayne Gatt's been quoted as saying, quote, "Within 13 days to run on this current state of emergency, it is essential that Parliament moves to maintain the framework that provides police and PSOs with the capacity to help Victoria safely come out of lockdown. There can be no adequate plan for a return to some normality if the framework designed to ensure it's done safely and incrementally is removed. This issue is above politics. The safety of our community and our members in this precarious time is too important," end of quote. And I certainly agree with the sentiment there from the Police Association that this issue is above politics.
Rick.
Thank you, Deputy President. I'd like to start with something that I've canvassed many times. The directions that are given by the CHO must be the least restrictive of rights. My question to the Minister is, how does the Minister receive assurance that these measures are actually the least restrictive of rights of all the possible measures that could be taken?
Minister.
Okay, thank you. And I thank Mr Limbrick for his question, because whilst he and I may philosophically disagree on our positions on many issues, and including on this bill today, at least Mr Limbrick asks worthy questions, sensible questions, and he's certainly done that at PAYAC. And he does that here as well. So I thank him for that, because we might actually get to talk about some more substantive things that are relevant to the bill with Mr Limbrick's line of questioning. So just in terms of the question that he's posed, as I've explained to the House, if in declaring a state of emergency, or seeking to extend a state of emergency every 4 weeks under the legislation, I'm required to seek advice from the Chief Health Officer. And I can only declare a state of emergency in relation to circumstances causing a serious risk to public health. In formulating the advice that the Chief Health Officer gives to me, he is required to consider the definition contained in the Public Health and Wellbeing Act, which states that a serious risk to public health means a material risk that substantial injury or prejudice to the health of human beings has or may occur. This requires the Chief Health Officer to have regard to the number of persons likely to be affected, the location, immediacy and seriousness of the threat to the health of persons, the nature, scale and effects of the harm, illness or injury that may develop, and the availability and effectiveness of any precaution, safeguard, treatment or other measure to eliminate or reduce the risk to the health of human beings. Now, in developing this advice, there are a number of statutory principles that sit under the Public Health and Wellbeing Act that I'm required to consider and that the Chief Health Officer is required to consider. These include the principle of evidence-based decision-making, the precautionary principle, the principle of primary prevention, the principle of accountability, the principle of proportionality, for example, whether the measures are relative to the public health threat, the burden of the measure and equity of benefit and burden, and the principle of collaboration. So all of these things need to be considered, including also the Charter of Human Rights and Responsibilities of implication on people's human rights, in considering what the risk is at that time, considering all these implications and having regard to all of these principles.